Workplace disputes and assaults. As criminal defense attorneys who are very familiar with the administrative world as well as some of the civil world as it relates to these kinds of cases, we want to kind of give our feedback on what happens if you have a workplace dispute or assault. And I think the first and foremost, the first thing that comes to mind is that you're going to have a manager that wants to get a statement from you right out of the gates, and the purpose of getting that statement may not be to serve your interest, it may be to serve theirs.
Yes, and if they are doing that, what they're looking at is, how do I keep my job? And I'm going to throw everybody that I can under the bus in order to do that. That's a problem for you. It's a problem for the other individual that was involved in the altercation, because they're not being objective. They're being self-centered and saying, this is what I need to do.
Bias, right?
Well, more than bias, it's insane.
Yeah.
And they'll continue to do that because that's what their focus is.
Well, as criminal defense attorneys and who litigate a lot of cases, we are acutely aware. The word bias is highly valuable because officers can have bias. Anybody can have a viewpoint bias where they're kind of subjectively serving their purpose or they have their assumptions up front. So you may have a history of being someone who is more outspoken, but in this set of circumstances, the other person suddenly lashed out at you for no reason. They may have a bias already against you, or a manager may already have a bias against you. And you have to realize, once you give a statement, if it has potential criminal exposure, which means you have an assault, which is an intentional touching of another that was unwanted, that statement that you just gave to your manager, even if it's written down and not accurate, is going to be told to the police officers, and it's going to be repeated later on as fact and as truth.
It's going to be handed to the police officers. They're not going to modify it. They're going to say, here's what he or she said, boom, take this.
Now you've got a problem in a courtroom, right?
Yeah, because now it goes from, were you lying then or are you lying now? Whereas if you hadn't made a statement or come in and talk to us first.
You're telling the truth once.
Right, and you do that in court. You don't do that prior, because at that point in time, they don't know what they're battling. And that makes it a lot more difficult for them to decide civil, criminal.
Well, and that's the benefit of being private counsel. As I have found, our job has grown increasingly managing investigations. There is some delay between when the police officers get involved and charges get filed, and because of the lack of funding over the last 5-10 years, that delay has increased. And what it has practically meant as criminal defense attorneys means that we can collect more evidence, we can get witnesses, we can get character evidence, people who will talk about the other person's reputation for truthfulness or for aggressiveness, and the officers may have not looked at a case on that level, or the manager may deliberately have averted or not brought up. We can bring that evidence in and collect it and present it to a prosecutor and avoid a criminal charge, even go on the offensive in the civil courts and file a protection order, which is something that is hot in workplace disputes and assaults.
Right, and in this situation as well, what you don't want to do is give a statement, because if you come in and talk to us, we're going to sit you down and say, okay, what was this really about? What led up to it? How long have you had a beef with this other person? How did it start? Is there defense of others? Is there self-defense? Is there property defense? Were alcohol or drugs involved? Was anybody intoxicated voluntarily or involuntarily? Who was the primary aggressor?
Jealousy issues.
Jealousy can be huge. What type of force was used? Was there excessive force? And remember, anything can be a deadly weapon depending upon how it was used. And most importantly, who else saw this go down? Because you're involved, the other party's involved, but anybody else who was involved, they're a non-biased witness, and their opinion is going to carry more weight because they're not involved in the altercation.
Well, and that hits on something that I think people underappreciate. The criminal defense attorneys, good ones, are not only trained listeners, so I can sit in a conversation for 20 minutes and just simply listen, but what is, I think, makes us unique, or somebody who is highly experienced unique, is their ability to ask critical questions. And you can't do that to yourself. And so when somebody else is examining your story and asking the hard questions that you might not ask yourself, you get a different perspective on how that case will be presented or looked at by third parties. And then of course there's the rules of evidence, which can turn chop a story up and prevent you from being able to tell everything that you think you'll be able to tell. And so it's important to have somebody assess that. But I want to talk more about protection orders as it relates to those.
Well, protection orders, anti-harassment orders, no contact orders, those are all things that can come in, and you could very easily be an individual who gets charged with this, but if you can beat the other guy into court, get a protection order against them, You may not be able to go to their workplace, but if they can't get around you and you're still back at the workplace, they lose their job, you don't lose your job, and that starts causing all sorts of collateral issues, which may very well prevent this thing from ever hitting court.
Yeah, and protection orders are really now, they're a lower standard than they're what
The preponderance of the evidence.
Yeah, they're
much lower standard.
Normally in a criminal case you have to prove something beyond a reasonable doubt. In a civil protection order proceeding you have to prove it by preponderance of the evidence. In a criminal court proceeding you're limited by the rules of evidence of what you can say, what's reliable. Interestingly enough, in protection order proceedings, because they were deemed to be fast, they have functionally said all evidence can come into a court, or I should say most evidence can come into court, and then the judge is going to make their own decision of discretionary
scales
decisions.
of justice. Maybe I let it in, maybe I don't let it in.
Yeah.
The more you tell them, that's how the scale gets weighed.
And they're familiar with the rules of evidence. I mean, they put weight
you
on
hope they
here.
are.
Yeah. Well, it's important for you to hammer that point home, or if you're a lawyer to hammer the point home. If there's weakness, if someone's just making an accusation, it's still just an accusation, and that's preponderance of the evidence from my perspective, 51%. So I have argued some very serious cases to neutral, where the judge looked me right in the face and said, I can't say what happened.
Right.
And that's an honest statement.
That's a win.
Yeah.
Boom, I agree.
Yeah. Anyway,
Call us.
call somebody.